The motion before the House tonight. This House believes the courtroom should not be a forum for advancing social justice. I first call upon Amy Gregg, Exeter College Development Officer at the Union, to open the case for proposition.
Thank you, Mr. President, for giving me the opportunity to speak here tonight. It's been an honour to work with you over the vacation and this term. Justice and the court are inextricably linked. Our judges are termed justices, and our legal process is the justice system. Lady Justice stands upon the roof of the Old Bailey Criminal Court, sword in one hand, scales in the other. But when we talk about justice in this context, what we refer to is legal justice. It demands that the law is applied to all people equally, that cases are heard by an independent and impartial court, that parties may hear the evidence against them, and that judges must come to decisions without bias. In contrast, social justice is considerably broader. Social justice aspires to a society in which everyone has equal economic, political, and social rights and opportunities in education, healthcare, employment, and their personal lives. In the words of the United Nations, we advance social justice when we remove barriers that people face because of gender, age, race, ethnicity, religion, culture, or disability. I aspire to a world of greater social justice. I nonetheless stand on this side of the motion tonight for three key reasons. First, the court is not an appropriate forum for advancing social justice. Second, the court is not an effective forum for advancing social justice. And third, the court's primary role, that of delivering legal justice, will itself be undermined if the courtroom becomes a forum for advancing social justice. However, before I move to the body of my speech, it falls to me to introduce tonight's opposition speakers. Our first speaker is Anjali Ramanathan, a second-year law student at Christ Church. Originally from California, Anjali has been described as possibly the only person born and raised in Silicon Valley who doesn't know how to code. Her commitment to social justice has extended to working with organisations that support women Democrats running for office in the US. It's just a shame that she was possibly the only American at Oxford last year that was too young to vote for Biden. Our second speaker tonight is Joe Morn, QC. He is a barrister and founder and director of the Good Law Project, whose mission is to achieve change through law. Mr. Morn may be interested to hear that the rules change that just passed included repealing the rather odd rule that within the union, a police dog is deemed to be a wombat and other animals are deemed to be a mongoose. For the benefit of any animal lovers in the audience, I can assure you that no animal is currently deemed to be a fox. Our third speaker is Helen Mountfield, QC. She is principal of Mansfield College and a practicing barrister at Matrix Chambers, specialising in human rights and equality law. She represented the winning parties before the Supreme Court in Miller, where she described one of her opponent's submissions as the equivalent of arguing that the Loch Ness Monster exists. Given her opponent was a top QC, I'm a little afraid of what she might have to say about my arguments tonight. Finally, our fourth speaker is Yasmin Ahmed. She is the UK Director of Human Rights Watch and the former Executive Director of Rights and Security International. She has successfully litigated issues ranging from arms sales in Saudi Arabia to investigations into crimes committed by government forces in Afghanistan. This has certainly put my own CV into perspective. Mr. President, these are your guests and they are most welcome. Moving to my first argument, the court is not an appropriate forum for advancing social justice. Advancing social justice implies some new change to the status quo, a new increase in rights or opportunities for a group in society. Forum for advancing implies something done deliberately and with purpose. As any first-year law student can tell you, our unwritten constitution strikes a delicate balance between the three branches of state. The executive proposes laws, Parliament passes new laws, and the court interprets, applies, and enforces these new laws. To cast the court as a forum for advancing social justice dramatically changes its role. Rather than simply interpreting, applying, and enforcing change brought about by Parliament, it tasks the court with itself affecting change. Rather than applying the law, it invites the court to reshape the content of laws that do not afford everyone equal economic, political, and social rights. This role, one of deliberate substantive advancement, is not an appropriate role for the court to perform. It is the role of the executive and Parliament. And this argument is a cornerstone of democracy, the principle that it should be the people, acting through their elected representatives, that have the authority to decide the rules that govern them. UK judges are unelected and are hugely unrepresentative in terms of gender, race, wealth, and educational background. As legal experts, they are perfectly placed to interpret and apply the law. But judges do not have the democratic legitimacy required to perform the role of policymaker. And this is what casting the court as a forum for advancing social justice invites them to do. My esteemed opponent, Ms. Mountfield, took great pains in Miller to reassure the Supreme Court that her case was not, of course, an attempt to persuade judges to usurp the power of any other arm of the state in an illegitimate way. It is my case tonight that to cast the court as a forum for advancing social justice does precisely this. This brings me to my second point, that the court is not an effective forum for advancing social justice. Crucially, if we encourage judges to make decisions in pursuit of social justice goals, this grants judges a degree of latitude that risks backfiring. Nowhere can this be seen more clearly than in the US currently, where the Constitution grants substantively more power to judges than in the UK. When cases like Roe v. Wade were decided, granting landmark protection to abortion rights, champions of social justice in the UK may have looked to the US courtroom with envy. Here was a forum where minority rights could be advanced without the long struggle through the political system that had faced abortion campaigners in the UK in the decade prior. Recent developments, however, have starkly revealed that this envy can be short-lived. As the composition of the courts change over time, what may be classed by judges as advancing social justice, and which rights are therefore protected, can vary dramatically. This is because social justice can mean something very different depending on whether you are liberal or conservative, whether you are religious or agnostic. In the case of a Christian baker refusing to make a cake for a gay couple, some will view banning this refusal as removing the barriers that people face because of sexuality. Others will view permitting this refusal as removing the barriers that people face because of religion. Both would undoubtedly view their own position as advancing social justice for those groups. Is the democratic process free of these different approaches and interpretations? Of course not. But outside the courtroom, we have the reassurance that we may select our political decision makers, that they are answerable to us, that we know their moral and political views, and that we may in some way influence the approach and interpretation they take. I have huge respect and admiration for the judiciary of the UK, but for the most part, I do not know their moral stances or their politics. I do not know Lord Reed's position on abortion, or Lord Hodges' views on gay marriage, or Lady Arden's attitude to religion. In a Britain where the court is not a forum for advancing social justice, this does not matter. In a Britain where it is, I struggle to see how we can ensure the court advances social justice in a consistent and predictable way. This is a lesson the US is fast discovering. This brings me to my third and final point, that the court's primary role of delivering legal justice is undermined if the courtroom is used for advancing social justice. In recent years, we have seen a dramatic increase in complaints of judicial overreach. Take the Daily Mail front page that labelled the High Court as activist judges and enemies of the people. Take Theresa May's accusation that the court subverted British democracies in immigration cases by permitting an illegal immigrant to stay in Britain because he had a cat. Politicians, the press, and the public increasingly contend that the court is illegitimately deciding social, moral, and political questions. I do not believe that either the Daily Mail front page nor Theresa May's comments are a true representation of the UK judiciary. but it is crucial that they continue to be untrue. By remaining within the confines of their institutional competence, the courts can resist such attacks and can continue to command authority. For every sensationalist tabloid article about immigration and cats, the court can point to its judgment and demonstrate that the outcome of the case was the result of applying legal rules, of the court doing its job, of delivering legal justice. By expanding the court's remit to advancing social justice, we grant legitimacy and power to the criticisms levied against the judiciary, and in turn, we justify steps taken by the government to restrict the powers of the court. We have already seen attempts to restrict the court in this way, from the motivations behind the independent review into administrative law, to the Lord Chancellor's recent proposal of a mechanism to correct judgments that ministers believe are incorrect. By venturing into the arena of social justice, the court will only legitimise and strengthen efforts to put the court back in its box. Our independent judiciary is under constant threat by politicians who would prefer the legality of their decisions, is not to be questioned. We cannot afford to assist those who seek to attack the court's ability to deliver legal justice. For all these reasons, I ask you to vote for the proposition tonight. Thank you.